The next presenter we have with us is Dr. Professor Shahbaz Ahmad Cheema, who has been in the profession of academia for the past several decades. When he graduated, he passed a exam to become a judge, but he opted to become a teacher, and to our benefit, I must say. He has written several books on his book on Islamic inheritance law is one of the most popular books in Pakistan in inheritance law, and he has also written with me a book on family laws in Pakistan. In addition to this, he has published several articles in leading national and international journals on various areas of law. So his specialty is family law and law of evidence, and today he'll be talking about law of evidence. So over to you, Professor Chima.
Thank you for this kind and generous introduction. Subject allocated to me for this particular purpose is law of evidence. Law of evidence is one of the major areas of law, and our law of evidence is has very rich history, very rich history, because when it was drafted in 1872 as an Indian Evidence Act. It was the first consolidated law at that time applied in the Indian subcontinent. Even at that time, in many common law jurisdictions, there was no codified law of evidence available. That's why if you see the books written on law of evidence in that period, you will see the extensive references to this particular law. Even American writers have extensively referred to this, and the writers in the UK, which is the birthplace of the common law, even those people have referred to this. And the author of this law was Sir James Stephen, and when Sir James Stephen left for United Kingdom after finishing his job in subcontinent, he was even asked by the House of the Lords to draft a law of evidence for British as well. So this law has a very rich history. That was a point I was just simply want to convey. And when Pakistan was created on this world map, Pakistan adopted this law as such. But during 80s, after in Zia's regime, there was a debate to Islamize the laws, and one of the areas pointed out in that debate was the law of evidence, and some of its provisions were specifically pointed out to be un-Islamic. That's why an effort was made, and different commissions reviewed various provisions of this law, and ultimately in 1984, Kanun-e-Shahadat order was prepared and it was implemented. Kanun-e-Shahadat order is basically based upon Indian Evidence Act, and those who have seen access the books of Indian Evidence Act or the 1872 law of evidence, they can simply compare those provisions. That there are numerous provisions which are basically borrowed from the Indian law of evidence, and they were engrafted into the Kanun-e-Shahadat order. So that's why when we try to explore what are the basic principles underlying the law applicable in Pakistan, then those principles are basically those which we borrowed from the Indian Evidence Act. So the author of the Indian Evidence Act in his introductory book has specifically pointed out that there are three common law principles upon which law of evidence is founded, and those principles are on the screen in front of you. The first one is evidence must be confined to matters in issue, and this very principle is the foundation of whole concept of relevancy and admissibility, and we will point out some of the provisions later on. So the next basic principle is exclusion of hearsay evidence, that indirect evidence would not be admissible. And the last principle is the best evidence rule. Best evidence rule, wherever possible, best evidence provided, and the evidence which is not as good, that should be discarded. So there are manifestation of this very principle. Then I would like to point out that when Kanun-e-Shahat order was replaced the Indian Evidence Act, it incorporated some principles derived from Islamic law. So the next slide would show those provisions which are basically borrowed from Islamic principles, or they are substantiated from the Islamic perspective. So these are the few provisions which are there in our Kanun-e-Shahat order, and these provisions are justified on the basis of Islamic injections. The basic concept in Islamic law, there are one of the very important principles is deals with the competency of witnesses, competency, gender, and these are the issues which are dealt in Islamic books of Islamic law of evidence. If you see any book of Islamic law of evidence, you will first encounter who is competent according to Islamic law. So the issue of competency, which was originally derived from the common law principle, that was mixed with the Islamic injections. And if you see the Article 3 and Article 17 in Kanun-e-Shahat order, you will see, notice the provisions which are from the perspective of Islamic law, that the competency would be determined in accordance with Islamic injection. And what are the Islamic injection? That witness should be other, witness whose evidence should be acceptable. So then there are provisions relating to gender of witnesses. For example, there is one specific provision basically that deals with that when there is evidence is required for financial matters, then it is specifically mentioned in the Quran that 2 female witnesses are required. So the provision is there in Article 17, and then issue of Tazkiyatu Shahood, and this Tazkiyatu Shahood is applied in Hudud and Qasas. So whenever the issue is of a severe nature, the penalty is of a severe nature, then the witness should meet the strict criterion of Islamic law. That's why the process of Tazkiyatu Shahood is there in Kanun-e-Shahat order. Though it is not specifically mentioned in the text of the law, but as according to the interpretations of the courts, the concept is there in Article 3 and Article 17 when those articles refer to the Islamic injections. Then the next article in which Islamic concept has been incorporated, and that is Article 16. In this particular article, the concept of Islamic concept was not originally incorporated. It was originally incorporated with respect to the hudud, and judiciary extended it with respect to the qasas as well. Because when 1984 Kanun-e-Shahat order was drafted, at that time there were only hudud laws, no law of qasas was there. That's why it was provided in Article 16 that the evidence of accomplice, co-accused, is not acceptable for hudud cases. It wasn't specifically, it is not specifically written in the text that it is not applicable for the qasas. This was according to the interpretation of the courts. And what standard of evidence is required for hudud, the same standard of evidence is required for qasas as well. So the accomplice's evidence, co-accused evidence is acceptable for tazir, but it is not acceptable for hudud and qisas according to Islamic law, and that provision is there in Kanun-e-Shahat. Then another concept that is provided in Article 17, this is basically acceptance of indirect evidence. If somebody is not in a position to appear before the court, because he is not no more alive or he is incapable of giving evidence, he can depute or confide his evidence to 2 witnesses, and those 2 witnesses appear before the court. This is known as shahada al-shahada, and this it is incorporated in Article 71. Then the provision relating to legitimacy and paternity, the Article 128, which has replaced specifically Section 112 of Indian Evidence Act. And according to this very principle, the provisions of Islamic law has been incorporated that the period of gestation would be which is provided there in 128, that is according to the Hanfi school of law, that the minimum period of gestation is 6 months and the maximum period of gestation is 2 years. And if a child is born after within this period, he is considered to be legitimate, and his legitimacy cannot be questioned on any ground whatsoever. Even DNA evidence is not allowed or permitted on these points. So according to the concept of law of evidence, legitimacy, the provision dealing with legitimacy is basically having a value of conclusive proof. So no one is allowed to go against this. So this is there. And then there is another provision. Most of us have a vague concept that in Islamic law, decisions could also be made on the basis of oath. So this concept has also been incorporated in Article 163, and this provision is not applicable in hudud and qasas, and most of the time this provision is applied in those cases where there are matter are of petty nature, and if evidence is not available, parties are required to go through the process of oath, and it is the discretion of the court to resort to this matter or not. So most of the time courts hesitate to resort to this matter, but when there is no other mode available, for example, there is no evidence available and only the parties are there who are the witness to the transaction, the court may, in its good sense, require the parties to go through this process. So these are the Islamic provisions which have been incorporated in the Qanun-e-Shahadat order. Interestingly, another provision which I haven't mentioned here, that is Article 151 and subsection 4, which has recently been expunged from the Qanun-e-Shahadat order on the basis of Islamic provision. You may see that provision there in Qanun-e-Shahadat order. So let's move to the slide number 5. These are the very important concepts: relevancy, admissibility, and reliability. And if one has developed his understanding in those basic concepts, the law of evidence would become very easy for him to understand. For example, the first concept, relevancy, is basically in common law jurisdiction, this concept was based upon the common sense and logic. But in our Qanun-e-Shahadat order, this concept is a legal concept. So the relevant facts have been described in detail in Qanun-e-Shahadat order. So whatever is provided in the chapter relating to the relevancy, what facts are described there, enlisted there in various provisions, those are the facts which are relevant, and whatever is not provided and whatever cannot be construed out of those provisions, that cannot be said to be relevant. So the basic concept is this, that whenever we say what is relevant, we have to go to the text and we have to interpret the provisions and say, okay, this fact is relevant on the basis of this very provision. So the relevancy under Qanun-e-Shahadat order is basically a legal concept, and whatever is a legal relevancy, that legal relevancy is most of the time substantiated or justified on the basis of logical relevancy. So when we say that this fact is legally relevant, more than 90% cases, it is possibility that it would be logically relevant. But if something is logically relevant, but not legally relevant, so that evidence of that particular fact cannot be provided. So we have to make sure that whatever pieces we are bringing before the court, those pieces be legally relevant according to some provisions of the law. And if that's not so, then the opposite party may point out these discrepancies in appellate stages, as pointed out by Ziaul Laranja in a previous presentation. So the next concept relates to the admissibility. Admissibility is a mixed question. Basically, it relates to evidence as well as procedure. It is not stricto sensu the question of evidence in our legal system. It has repercussions. Evidence of relevant fact is allowed by the court to be presented before the court. When something, some kind of evidence is allowed by procedural law to be presented before the court, that is that convert the relevant evidence into the admissible evidence. And when something is relevant, but legally that could not be presented before the court, that is legally not admissible. So there are provisions in Kanun Shat order, for example, from article 4 to article 15, and those provisions exclude those provisions. So the evidence is legally relevant, but that is not admissible. That is not admissible. So these two concepts are there, and they are a bit different from each other. Legally relevant evidence is allowed to be presented, but when that should be presented, it would be administered by the procedural law. And when that sometimes legally relevant evidence is not allowed to be presented before the court, and that converts that evidence into inadmissible evidence. So the next point is of reliability. This is the question which has not been dealt by the Qanun Shat order. If evidence is relevant, that can be allowed to be presented. If evidence is admissible, that evidence is admissible. But the question is whether the evidence which is admissible, that is reliable or convincing or not. This point has not been touched by the law of evidence. Law of evidence has just dealt with the evidence or its different kinds. And as far as the reliability of that very piece of evidence is concerned, that has been left to the logic and common sense. And the court has to evaluate the reliability of that very evidence on the basis of circumstances and different kinds of evidence and the demeanor of the witnesses and like this. So the reliability is not a question of law of evidence. Reliability is a question of common sense, question of logic, not dealt by the Qanun Shat order. In our second or third slide, probably we enumerated three basic principles on the basis of which Qanun Shat order is founded. One of them is that evidence should be confined to matters in issue. There is as I pointed out earlier, there is an extended list of those facts from Article 18 to Article 69, and you will see the res justae, motive, preparation, alibi, evidence pertaining to similar facts, and this and that, expert opinion, character evidence, relevancy. These are some of the provisions which I have highlighted just to make the point that generally these are the matters on which the evidence could be presented before the court, and they have been held by the law of evidence as relevant facts. And the next principle on which law of evidence is based that relates to the exclusion of evidence, and this very principle is specifically mentioned in Article 17, where it is mentioned that oral evidence must be direct, and what is not direct, that is indirect, is hearsay evidence. Hearsay evidence is excluded. So whatever is perceived by the senses, five senses which we all are endowed naturally, if that is conveyed to the court, that is termed as direct evidence. Interestingly, this word hearsay hasn't been used in law of evidence. In Qanun Shat order, we have used the word direct, and direct is basically symbolic representation of exclusion of hearsay. This very principle, exclusion of hearsay evidence, that is basically direct evidence. Okay, and why the indirect evidence is not accepted? Because the evidence which is not before the court, which is statement given somewhere out of the court, without any oath, without any possibility of cross-examination, without any fear of perjury or judicial sanction, why should that evidence be given the same status which is accorded to the witness who is before the court and who is giving evidence on the basis of what he has personally observed? So the person who has observed some fact and he has narrated that fact before the court, his evidence is direct. But the person who has not observed any fact and who has been communicated by somebody else that something happened, so this evidence is indirect evidence. So this kind of evidence is basically excluded, not allowed to be presented. And the whole, if you see the law of evidence, Qanun Shat order, we will see that that this principle is there as one of the foundational principles, but then there are various provisions in which exceptions are provided. For example, Article 19 relating to res justae, extrajudicial admission and confession. Technically, this is indirect evidence, Okay, dying declaration, somebody has made a statement about his death out of the court, and whoever has heard that statement, he comes before the court and gives that statement, whatever he has heard. So these kind of the statements are basically indirect evidence, but they are allowed to be presented before the court on the basis of circumstantial guarantee. So sometimes statements are made in those circumstances in which the probability of truthfulness is engrafted into those statements, are inherent in those statements. That's why sometimes in exceptional circumstances, indirect evidence is justified. So dying declaration, statement made before another court, they may be produced before the some other court, and then statement made in special circumstances. These are articles are mentioned before though here, and you can see that in these provisions, basically the indirect evidence is allowed to be uh, entertained in the court. So the principle of hearsay evidence is there, and then there are extended list of exceptions. Similarly, the next basic rule is best evidence. This best evidence rule implies that if in a given situation, the best evidence should be presented. If we have two, three kinds of evidence, so whatever is best among those, that would be presented before the court. And the practical application of this is in specifically in two different situations. When documentary evidence is preferred over oral evidence, there are provisions, Article 102 and to 110. We see that documentary evidence is preferred over oral evidence, and then two situations are specifically mentioned in the law, and then there are lengthy list of exceptions in which oral evidence may be adduced. And the first situation is when law requires something to be written, so that whatever law requires to be written, that could only be proved through written document. And another is when some transaction has been voluntarily written down by the parties. So when parties has voluntarily written down a transaction, that should be produced before the court. So these are the kinds of situation in which documentary evidence is required and oral evidence is generally excluded. But in exceptional circumstances, for the purpose of explanation of different circumstances, the interpretation, and then if something is clear in the is not clear in the document, and what parties intended by the description in the document, these are the things which can be elicited through oral evidence. But the general principle is documentary evidence is preferred over oral evidence, and that is the basically representation or manifestation of best evidence rule. Another principle of primary evidence is preferred over secondary evidence. Why primary evidence is preferred? Primary evidence is normally the original evidence, what the court requires to be produced before the court. That is in normal circumstances is the original document. So original document is is a good evidence as compared to its copies, a derivative evidence. So that's why preference of primary over secondary is manifestation of best evidence rule. And then public documents are produced through certified could be proved through certified copies. And why they could be proved? Because certified copies issued by the public office evidence, they are the best evidence. And then there are list of presumptions included in the law of evidence, that whatever is issued from the public office, that has some sort of sanctity. So the presumption of genuineness is sometime attached to those things. This is because of the that was the best evidence, and some sort of sanctity or genuineness should be ascribed to them. And then as far as the parties who are required to prove something, there are two different ways to prove. First is by producing evidence, and second is relying on the basis of presumption which is in their favor. So that's why I have tried to present this very concept in one presentation, that parties who are under legal burden to prove something, if a presumption is in their favor, so that presumption is basically relieving them from the burden of proof inherently placed upon that party. So that's why presumptions are basically substitute of evidence. Presumptions shift burden of proof. So presumptions are of three kinds in law of evidence. Law of evidence, if you see, but broadly speaking, we can divide into presumptions of fact, which are rebuttable, and they are provided in 129, and the list provided in 129 is not exhaustive. Court, in its discretion, may craft some more presumptions of those nature, and then presumptions of law are there in from Article 19 to 90 to 101, and these are basically rebuttable presumption that the opposite party may produce evidence to rebut those or contradict or controvert the presumptions. And then there is a kind of presumption which is known as conclusive proof. It is basically presumption of law because it has been created by law, and it is a irrebuttable presumption. That's why we say that presumptions of law may be rebuttable or irrebuttable, but presumptions of fact are always rebuttable. So this irrebuttable presumption is there in two provisions of Qanun Shat Order, Article 55 dealing with judgments, and then 129 dealing with legitimacy and paternity. And as far as the burden of proof is concerned, that is of two kinds: legal burden of proof, which is primarily on the plaintiff and prosecution in civil and criminal cases respectively, and then the evidential burden, which sometimes is referred to in our courts by onus of proof. And evidential burden keeps on shifting on the parties, keeping in view the nature of facts as well as the evidence adduced by the parties. So there are provisions in which we can notice that the plaintiff and prosecution is basically under legal obligation to prove his side of the story, and then the burden is on the defendant to negate the evidence adduced by the, and that negation is basically under the concept of evidential burden of proof. So let's come to the point of examinations and leading questions. Law of evidence is so extensive, we are just rushing towards conclusion. The examinations are of three kinds. Examination in chief conducted by the party who has brought the witness in the court, then cross-examination by the opposite party, and then there is a third kind of examination known as re-examination. Examination of in chief and cross-examination should relate to the relevant facts. They can't go out of the relevant fact. And then there is a very important concept of leading question, the question which suggests answers. This type of questions cannot be put in examination in chief, because when such type of questions are put, they basically remind the witness what might not be in his mind at that particular time. So, but the opposite party, which is that is conducting the cross-examination, that party can ask leading questions. Okay, and the leading questions on some undisputed matters may be asked in cross-examination in chief and re-examination. For example, if a witness is asked by the party, "What's your name? What's the name of your father? What's your relationship with the party?" So these are the questions which are most of the time proved or not disputed. That's why a question could be raised, leading questions could be raised on that very points. And then there is a concept of hostile witness incorporated in Article 150, and according to this very provision, a witness who was brought by the party turned against that party. Note, because the witness has turned against his own party, the party who has brought that witness has a right to put questions which are basically cross-examination type questions. So this right is granted because of considering the fair play. So each and every party should have a fair opportunity to elicit the case, because the witness who was originally supporting his case now turned against him. So the party should have been given the right to question him, like which are generally put in cross-examination. Evidential value and Qanun Shahadat Order, So most of the time when we deal with a specific kind of evidence, we are asked the question, what is the value of this evidence? So the value of the evidence, when we don't find provisions relating to the value of different kinds of evidence in law of evidence. So there are only two provisions in which specifically evidence, value of evidence is mentioned. One is relating to the accomplice, that accomplice is evidence in cases of tazir without corroboration is acceptable. So that is there in Article 16. And then there is Article 43, in which the value of evidence is specifically that co-accused evidence carries the value of circumstantial evidence. So this is specifically mentioned in the law of evidence. The rest of the law of evidence doesn't deal with the evidential value of, for example, different dying declaration. What is the value of dying declaration? It is not mentioned anywhere, but the courts have decided. What is the value of confession and different kinds of confession? What is the value of expert evidence? So these are the things which are not specifically provided, but one concept which, if kept in mind, that basically the evidence relating to the relevant facts, and most of those facts provided in law of evidence, the evidence relating to those facts is treated as secondary, corroboratory, and confirmatory type of evidence. For example, evidence of motive, evidence of expert opinion. This is secondary type of evidence. And evidence of confession is generally treated, particularly judicial confession is of high quality evidence. Judicial admission is of high quality evidence. No corroboration is required, and no outside or extraneous substantiation is required. And similarly, the evidence of dying declaration, if dying declaration is proved, and the court may rely upon it without any specific corroboration. So the concept of corroboration, which basically requires some sort of outside support or confirmation. If somebody, one piece of evidence is there and that piece of evidence is supported by another piece of evidence, the another piece of evidence basically corroborating the first piece of evidence. So most of the time evidence is corroborated. Accomplices evidence is corroborated. Child witness evidence is corroborated. Police witness evidence is corroborated. So the evidence of most of the witnesses, most kinds of evidence is basically corroborated by other pieces of evidence and or other witnesses. But there are few exceptions in which courts are of the view that these evidence, dying declaration, judicial confession, judicial admission, where the court is of the view, judicial practice applicable in Pakistan or followed in Pakistan is that these types of pieces of evidence could be accepted even without corroboration.